All right, with us now, CNN Chief Law Enforcement Analyst John Miller and Defense and Trial Attorney Misty Marris. We can talk about that a little bit again later, but John, since we have you here, I want to focus on a lot of the new developments in this case. And the major one is that the father has been charged with manslaughter and second-degree murder very quickly. What are the events that led to this arrest and the speed with which it took place?
Probably three key things. First, there was the fact that his son, once taken into custody as the shooter, began talking to police. They say voluntarily. They say after being Mirandized, you have the right to remain silent, and has been cooperating throughout. So a lot of information about where the guns were stored, whether that gun was his, if he had total access to it or partial access to it, certainly enough access to it to leave the house with it concealed, fully loaded, and to, allegedly commit these murders. Part one. Part two, they conducted a search warrant at the house where they would have seen the physical setup of where and how guns were stored, whether or not they were secure, whether the ammunition was stored or secured separately. And at that same time, they had the opportunity to, again, interview the father, who, you'll recall, in the earlier encounter with the Jackson County Sheriff said, well, he does have access to the guns, but they're not loaded. But he wasn't clear on, well, is the ammunition there? Could they be loaded? So that was before he had gifted, allegedly, this child his own gun. All of those elements taken together, if you compare it to the Crumbly case, right, where the charging of the parents took a long time and a lot of consideration. It was based on, the prosecutor first seeing a social media post and then conducting a longer, complex investigation. This came together very quickly because all the elements were there, almost in plain view.
How big of an issue is it that he was already contacted? The father and the family already contacted the year prior, asking about these ideations from the son. Did that help push this forward much quicker? Because there had already been this interaction with police about this very issue that ended up happening.
So that's going to be a key factor, and Misty will get into this more, but it'll be a key factor at trial, which probably influenced their decision, which is, you want to, when you're doing these charges that are about reckless endangerment or reckless disregard, the charging decision is made, would a reasonable person have known that under this set of circumstances that something terrible could have happened, and would a reasonable person have taken steps to prevent that? In the case where you are giving your child a semi-automatic rifle as a gift for his own use, after you've had a visit from the local sheriff who's been tipped by the FBI, who's been tipped by members of the public, that your son's computer is allegedly the origin point for the promise of a school shooting. And remember, one thing is I'm going to shoot up a junior high school like tomorrow, but the other threats or the other things found in that computer is I'm going to do a mass shooting, and it's going to be a year or two. I'm not ready yet. Those kind of red flags, which is now a legal term, those kind of red flags, when you say, I'm going to wait months after that threat and say, I'm going to give him his own AR-15, would contribute to that idea of, would a reasonable person not know that this could create a clear and present danger to others?
Misty Marris is with us right now. Misty, to the points John was just making, how does that play in a courtroom?
Yeah, John makes excellent points, and he's absolutely right. And a critical piece of this case is going to be that timeline. So you're talking about May 2023, this interview takes place, the father is involved, the son is involved, and then December 2023, the gun is purchased. And what happened from December 2023 till the present day? And a lot of this case is going to depend on what the father knew or should have known. Remember, when we talk about manslaughter, we're talking about the standard of reckless disregard to a known risk. So it's based on acts, but also omissions. Knew or should have known. We've seen a whole slew of family members come forward and talk about issues that the defendant has had. And perhaps they were also interviewed by law enforcement, leading to this determination. But something different about this case, a unique distinction from the Crumbly case is that not only do we have these manslaughter charges, we also have 2 second-degree murder charges. That is very different. This is a whole new legal landscape because in general, the second-degree manslaughter statute or second-degree murder statute that we're talking about, murder that occurs in cruelty to a child in the second degree relating to those 2 killings, that's generally an individual, the actor, is committing an act of child abuse that unintentionally leads to death. Now we're talking about somebody being held responsible for the act of another. So that is a new, very novel legal theory, and that came quite quickly. So law enforcement were reading the affidavit, but they may know more specifically about this timeline, this critical timeline between May 2023 and the present day.
I just want to mention, because next to you, Misty, are all of the victims here. Richard Aspinwall, Christina Irmi, who was, by the way, celebrating her birthday when she was shot and killed with her students. Mason Skirmhorn and Christian Angulo. Their families are sitting there watching all of this. They're in tears. They're holding, stuffed animals. And it is a heart-wrenching scene inside of that court. But I do want to take you into court and talk about what happened with the judge and this charge and the consequences of the potential case to this young shooter as we wait for the father to also be arraigned. In what we expect are a few minutes. We're seeing the family members there reacting to the alleged shooter coming back into court, and they're just obviously devastated. But what about this charge where the judge had to call him back in? Why did he have to call the defendant right back in and say, hey, I'm sorry, you will not be facing the death penalty?
Yeah, Sarah, that was a critical correction. That was an error. So if he were an adult, then yes, the death penalty would be on the table. But the Supreme Court has clearly stated that the death penalty is not a penalty that can be in place for anyone that is a minor. In fact, even life imprisonment without parole, ever since 2012, a case called the Miller case, has to have a specific hearing that predates any sentencing to assess whether or not a minor can actually serve a life sentence without parole. So it was important for the judge to clarify that record, that the death penalty is not an option in this case. From a legal perspective, that is something that could potentially muddy the record or be problematic down the road if it weren't immediately corrected. So there's a lot of considerations when you're talking about a minor that don't apply to an adult defendant. So the judge acted pretty swiftly to correct that error.
Yeah, and people should know he is being charged as an adult, but that doesn't mean all of the rules that adults have to face when they're 18 or older children can be subjected to that. Misty Marris, John Miller, do not go anywhere because we are waiting for the arraignment of the father just shortly here.